for you today on the topic that is lined up for us. And yeah, as you can see, they are still joining us. The numbers are growing and we are excited. We believe that it's about to be a very exciting session. Yeah, karibu sana Wasili. So allow me to read one comment before we jump back to you. We have Superior Ronja also joining us from Mombasa, and I believe we have representation from all over Coast and Eastern branch today, this evening, just that maybe they were not able to indicate in the chat section. But yes, Wakili, we have a very wide audience today. And as you can see, members are really excited to hear from you. So, Chair, thank you for the remarks, for the introduction that you've given. We will go straight ahead to welcome you to give your remark.
Before that, let me, Wakili, tusalamia hapa kwa panelist hapa.
Yes. Good afternoon, it's evening now. Yeah, I'm honored to be part of this team. Again, I think for the second, if not that time, Peter Kinyanjui, practicing advocate and member of the Institute. Yeah, just to try and interact with my colleagues on this subject of compliance with human resource management and primarily the Act. So I am sure you will guide me through, and especially at Florence, and more so where there are any charts coming in through, so that you can guide me where maybe I intend to make it more interactive. I will still share what I have, but I will, as much as possible, wish to be more interactive than just reading through the slides. Thank you.
Thank you very much, Peter. Back to you, Florence. You can now engage the team as you can give the number to, I can see the number is growing up. Yeah, just proceed from there. Thank you.
Amazing. Asante sana, Chair. Thank you for stepping in for that. Wakili, again, karibu sana. We are really excited to hear from you, and we are honored to have you as our fellow member of the Institute of Human Resource Management. So allow me to take it back to you, Chair, so that you can give your opening remark as we proceed. Karibu sana, Chair.
Okay, thank you very much, members. I want to believe we already set, we are the number 44 now. Members, just to welcome you to this program. It has been a while since we planned just looking at the compliance. I appreciate that we have had engagement here and there. We had a physical meeting the other day in Mombasa, in Taita, and we are also planning for a physical one in Kilifi, probably with the Kitui. Our essence is to engage all the people in all the level, and we will wish to have many branches as we could wish, particularly Coast Eastern. Coast Eastern is wide, and we cannot manage every bit of Coast East. Around 8 counties in Eastern and 6 counties here in Coast. Coast alone, 6 counties, we are not able to maybe run all through. So having an online program helps us to reach so many people. And well, that is our case, is that we will wish to, we will keep on trying at least in every area. We have a branch. A branch just requires 30 active members, rather members in good standing. And then the branch is open. So for now, we are at advanced stage for Taita Taveta, and I want to believe soon we'll launch a branch in Taita Taveta. And we are trying also to engage for Kilifi together with Kitui. So having said that, I don't want to waste a lot of time here because the day is, let's talk about compliance. I know Peter Kinyanjui, Wakili is good also in data protection. Probably maybe he will loop in something about data protection maybe towards the end. But actually we will organize for a day for data protection alone, so that we get, I know that is what is at the moment, what is there at the moment. We need to discuss, have it. It is affecting us, all of us in HR. So probably we will have a look at it in a different way. So having said that, I just welcome everyone, welcome members, welcome to this webinar. Let's discuss, and I want to believe we will enjoy and we will learn. Thank you very much. Back to you, Florence.
Okay, thank you so much, Chair. We appreciate you welcoming us, and also for your remarks. You've had members, those are the remarks of the Coast Eastern Branch Chairperson, Isaac Boyd, for those who are just joining us. Karibuni sana. We are excited to hear from Advocate Peter Kinyanjui on HIM Act compliance. Members, my name is Florence Nkangondi Fundi, a HR professional from Taita County, and I'm honored to be the moderator of this session. And most importantly, I look forward to learning alongside you from our facilitator of the day. Bwana Wakili, this is your moment. We are ready to hear from you. Human resource professionals all over Kenya, as the chair has just spoken, are tasked with helping organizations when it comes to compliance with different legislations, in terms of employee progression, and in terms of also the development of organizations. And so we are well poised when it comes to different legislations. But the question remains, how well versed are we with our very own legislations, the very legislations that govern us as human resource professionals? So today we are honored to be taken through that very topic by Wakili Peter Kinyanjui, who is also a fellow member of the Institute of Human Resource Management. Members, Advocate Peter Kinyanjui is an advocate of the High Court of Kenya. He's a member of the Institute of Human Resource Management, and is also a certified data protection officer by the Professional Evaluation and Certification Board. In terms of his academic qualifications, he holds an LLB from the University of Nairobi and also a diploma from the Kenya School of Law. He has vast experience in different areas, being an advocate for years, and is currently the managing partner at Mwangi Kinyanjui and Company, which deals in employment law, human resource management, and data privacy. I mean, from that profile, is there any better person to take us through this topic? I do not think so. So kindly join me in welcoming Advocate Peter Kinyanjui in the question and answer section with drum rolls, please, as we welcome him to take us through the topic of the day. Wakili, karibu sana. We are honored to have you here, and we look forward to learning from you. Karibu sana, Wakili.
Asante. And thank you, Florence. Thank you, Chair. And good evening to the participants. As introduced, my name is Peter. And I have been part of this team in coordinating, or more or less engaging in dialogue on human resource mainly, and of course the supporting legislations that guides the profession. And I know I'll be guided by Florence about the timelines. I know we don't have much time, but then again, I also know this act is not a very new act, so I will not be taking you through the act itself. And from my engagement, I know most of us don't like reading acts of parliament in the first place. So I will spare you that, but I just use mainly my practice and more or less, more so focus on the emerging areas that human resource practitioners should be at all times be aware of. And maybe as a way of introduction, just to capture the generality of this critical act of parliament that was enacted in the year 2021. The general spirit here is was to entrench human resource management as a profession. And this is akin to other regulated professions, be it legal, where I practice is highly regulated. You can't just go out there and present yourself as an advocate. And if you do so, there are serious penal consequences for doing that. You have seen other professions like medicine, architecture, engineering, I mean, name them. Most of them, they would be regulated by the law in addition to them self-regulating themselves in the interest of ensuring that there is professionality in human resource administration. And as many of us would have are aware, is what led to this transformation is that prior to the enactment of the act, basically everybody could be a HR. In fact, there was a very common narrative that if you were not sure where one would function best, then you make them the HR. Yeah, so you could find an accountant being the HR, an admin being the HR, a lawyer being the HR, as opposed to now what is under the act that defines HR as a profession and criminalizes anyone who is not registered under the act and who is not qualified under the act, even not only practicing, but even using the title itself. Even using or representing yourself as a human resource professional, whether you're calling yourself a human resource manager or officer or assistant. I mean, as long as you use those, the title human resource, anything that could or would naturally be construed to represent you as a qualified human resource practitioner, then if you do not have requisite qualifications and are adequately licensed to practice, then you're violating the law and you'd be looking at what are the penal consequences that would be occasioned on any such person that would be presenting themselves as a human resource practitioner not qualified under the Act. But at the same time, in my engagement and short presentation, I'll also be highlighting what that also means to us as a human resource practitioner. Because it is one thing for the profession to be protected, but then once it is protected, there is a requirement that those who are duly registered and licensed must carry out themselves in a certain set code of conduct. And that, again, failure to follow that kind of conduct as expected of a human resource practitioner, then also leads you to consequences. And this you've seen happen all over the other profession. If, as a lawyer, I give advice to a client to their detriment, which is not professional, that client can sue me. The client can sue me for professional negligence. We have followed cases of doctors, maybe who during some surgery forget to close in some blades or some swabs into a person, into their patient's body. And you know what that happens. You have seen suits about patients who may be succumb because they feel that the doctor did not observe highest professional, the highest professionality in carrying out a certain medical procedure, leading to them losing their lives, losing functions of their of body parts, or even death, absolutely, either of them or their children. And you've seen these being very grueling court battles, and that are also very expensive on account of either the medical facility and the practitioners themselves. If a building collapses, we will go for the person who designed those, the architects and all that, engineers, they will go for them, just in case they didn't do what they were meant to do. So the generality of my conversation today would be, first of all, looking at it now being a protected profession. But then again, what that imputes to you, who is now duly registered to use that title, human resource practitioner. So I will share my slide, and on that, maybe if you allow, I'll pull down my video. You will, Florence, you will guide me when maybe there is a question that I may need to respond to. And yeah, so that if need be, it can be asked out or just read out in chat so that we make the session as interactive as it possibly can. Very well. And I will be using slides actually from the Institute itself on some compliance, which I will share at the end of the presentation, so that we don't have to start all, because this is an area that has been widely discussed, and since 2012, it's how many years? More than 10 years. So it's an area that has been very well interacted with. And I am glad that a lot of compliance, we get to see a lot of compliance, and especially for us who practice in the Employment and Labor Relations Court, where every other time we get human resource practitioners coming to justify their practice, and especially in cases of terminations, or let me use the separation generally, inevitably, and perhaps I can just use that as a way I manage my cases when I go to court to represent companies in cases where they have been sued by their former employees, maybe on cases of unfair termination, discrimination, unfair labor practice, and so on and so forth. You will find that in many cases, the Law Employment Act under Section 41 would dictate that that separation must be executed in line with a fair process. And therefore, inevitably, the HR comes in to ensure that the person who has been separated has the process that led to the exit is in compliance with the law. Normally, the court will be asking for 2 items to see whether the termination was justified within the law. And one of it would be to prove the grounds upon which the separation was predicated on. And the other one would be to prove the process pursuant to which the execution of the separation took place. Now, the first part isn't usually very difficult to prove, because you are assuming somebody did not come to work and they have no legal justification about their absence. So that in itself constitutes a ground for separation under Section 44 of the Act. But then again, the fact that you have the reasons, you have justification, you have grounds, on its own will not midwife a fair separation process unless it is also coupled and supplemented by a fair process. And this is where HR management now come into place. This is where now the HR who will be in court will be required to give evidence about how they executed the separation. And this is now where we will now, as in the course of the presentation, I will give you some insights of court and how the court then in that case would be expecting of you, having introduced yourself as a HR manager. And the judge will be looking at you to ensure or to confirm that you actually did commit comply with the Employment Act and the constitutional right of such employees in executing that administrative process that would have resulted to somebody losing their job. And that is exactly now where we should focus this presentation on, to see what is expected of us as human resource professionals in executing our mandates as employed by our respective organizations. And I know, as I am sure most of us represented here would be, is we are employed as management team, meaning we represent the owners of capital as managers. And therefore, the actions that we do are taken to be the action of the company that has employed us to represent it on matters human resource. And in that case, this is why now a lot is put into focus about your professionalism in advising capital, and ultimately in defending the capital in the event of disputes, whether at the labor office, whether at the employment courts, as it happened. It has even gone up through to other higher courts, all the way to the Supreme Court, especially if it is an issue that touches on wider public interest, even if it is in public, even if it is an issue of employment, but with a wider effect to the entire maybe Kenyan citizenship. So the Act, as I've said, came into force in the year 2012, and it is basically meant to, first of all, provide a legal framework for regulation of activities of human resource professionals in Kenya. And as you can see, the keyword here is regulation of activities. And this means now, whatever it is you're doing at the workplace, whatever policy you're coming up with, whatever policies you are putting up, whatever practices you have introduced in your organization would have to be reflected whether it is what a human resource professional as registered and licensed in Kenya should put in place, and whether it conforms to the expected standards of a human resource practitioner. And on this case, I want to maybe single out a practice that has been introduced in a certain company. And as much as this practice is not codified in the human resource manual, or is not codified in the employee's contract of employment or the code of conduct, ultimately, that practice in that company, as presided over by a registered and human resource professional, will be mirrored both in line of whether it is actually fair, and also whether the person who has been presiding over that practice in that company is actually a registered human resource professional, and whether they are discharging their practice professionally. Now, other than the Employment Act, which I would say is an act of parliament similar to the Human Resource Management Professionals Act, if you look at the acts that even have more superior force over these acts that govern employment, I will also be looking at the Constitution. For instance, what does the Constitution of Kenya provide in terms of what it expects at your workplace? Remember, since the promulgation of the Constitution, that is in the year 2010, for the first time, the Constitution of Kenya incorporated labor into the Constitution, labor rights into the Constitution. Before then, they would have been mostly provided under acts of parliament, and therefore they would have ranked in a manner that would be said subordinate to the Constitution of Kenya. But with the onset of the Constitution and introduction of Article 41 in the Constitution of Kenya, now everything else is mirrored against the constitutional mirror. Whether it is your policy now, whether they are your procedures, whether they are your practices, we must always go back on the spirit on how HR administration and labor administration should be under the Constitution. For instance, every employee under the Constitution has a right to fair labor practice. That is a very sweeping, is a provision with sweeping powers that it is superior to what Acts of Parliament provides. And if the Acts of Parliament goes against what can be deemed to be a fair labor practice at a workplace, then that other Act of Parliament would be declared null and void, given that a constitution is supreme. And I'm saying that is an Act of Parliament. Now, I want to go down from the Act of Parliament. You'd have other regulations, and these regulations would include maybe the wages orders for different kind of setups and sectors. Again, these regulations must be coined in a way that it is or gives meaning to fair labor practice. Now, come at your workplace, the perimeters of your workplace, where you have got now a lot of policies borrowed from the law, borrowed from operational requirements, borrowed from practices and even customs, culture, or call them, or name them whatever they are known as. Now, even if they are not codified, then you must always look at them and interrogate them against the scales of, is it a fair labor practice? So this is part of what the Acts provides, that there is a legal framework and to regulate activities of human resource professionals. And at this juncture, I will not go back towards the qualifications for human resource managers. I am sure these are things that we are now aware of. I am very sure most of us are registered, whether as associates, whether as full members, and that is something that has seen quite a huge compliance with the same. So I will be moving now from what is now expected of you in executing your duties pursuant to that registration and licensing as a practitioner in human resource in Kenya. This Act also provides for regulatory framework to ensure that the human professionals are competent and practice HR in an ethical manner. And again, just to pick a few things about the happening out there, here, whenever there is an incident at the workplace that leads maybe to an employee being treated in a manner that may not be dignified, or they are not ethical, or they are not happy. Whenever these issues goes out there and plays out, whether in the public gallery through social media, or even in court processes, which are also, as you are aware, also public, they are heard out in public. There is no way that we can discuss issues of treatment of employees at a workplace without asking whether that organization has a human resource practitioner. There is a case that I know touched on media across the country, where in one of the companies, some ladies were paraded, I think, ordered to strip naked to just find out who had disposed some used sanitary pad. I'm very sure you are alive to that, and you know the kind of fire that kind of incident was treated to. And the underlying there would be, did we have a HR? And if, and from the media, what was coming out that this was not the first time that this happened. Was there a HR person presiding over these kind of practices? practices. Now, those are the areas we need to interrogate ourselves, and more specifically also in also looking at then what the role of the regulatory body that is also introduced under the Act has to ensure that these malpractices does not happen. Remember, the spirit, the preamble of the Act is an act of parliament to regulate HR practice. Regulating HR practice is ensuring that the practices that are at the workplace throughout employment in Kenya are run professionally. And again, let me underline that, because here professionally means you are supposed to act independently. Like, for instance, if the capital requires advice on matters finances, I am almost certain that they go to a registered practitioners in finance, registered under ISPAC and bound by the code of ethics of that regulation or self-regulation body. In discharging your profession, you are not supposed to take instruction from non-qualified persons. And I know this is where most of us would be limping, because many at a time and many HRs find themselves just executing what they have been asked to do. And in doing this, we forget that you could actually lose your license. As we will look at that, I will share, I will not go through the code, it's quite voluminous. There's a code of conduct. I don't know whether we have come across it or we are aware of it. There is a code of conduct that was published through the Kenya Gazette on the 19th of November, 2021. I will be sharing it because it's quite voluminous, and it is basically prescribes how, as a HR practitioner, you should act. But other than that, which maybe I will highlight just a few as I proceed on, I will now want to look at this body that is also statutorily established to regulate HR practice in Kenya. And this is the Institute of IHRM. And I want to believe what we are doing today is part of the mandate of IHRM under the Act, the 2012 Act. In this case, IHRM is mandated to register HR professional, meaning there is a register of all HR practitioners. Ideally, it means that anybody can be able to call into the institute or request through the procedure set in place, seeking to establish or to be given confirmation that Mr. X or Madam Y is actually a HR professional that is duly entered into the register of the human resource practitioners in Kenya, whose custodian is the IHRM. And this I have seen again in my practice in court come out to play out in court, and especially where somebody, maybe this would be your former employee, or even the court in its own motion, having doubted. Remember, the judge there would be an expert in employment matters. So he's an expert in the Employment Act, the Safety at Work, and all the labor legislations, the Labor Relations Act, the Labor Institutions Act, name them. This is what the Employment and Labor Relations Court implements. And now, post at that moment, when you find somebody who comes in court to offer testimony and they introduce themselves, my name is Peter Kinyanjui, I am the HR manager at company XYZ. Now, two things have been happening. One is the court on its own may ask you to introduce yourself through a credential to show that you're indeed registered. And I have seen these stop HRs on their, freeze on their feet. And I want you to see the gravity of what it means to be registered as a professional in a certain field. Because what makes you as a professional is not the title that you hold. It is the fact that you are licensed and registered to practice. I could be a lawyer, but not a practicing advocate of the High Court of Kenya. I only become a practicing advocate of the High Court of Kenya if I have a valid practicing license for a certain year in question. And it is the same that maybe if the judge was to doubt or somebody was to question whether I am duly licensed to practice law in any court, they are allowed to raise it before the judge. And at that point, it will be upon the judge or upon me to demonstrate through a practicing license or even through just perusing through the register or the roll at the Law Society of Kenya to establish that I am indeed a registered human resource professional. And you can tell what that would mean if you're not able to establish that you are indeed licensed to practice, because that would mean you are violating the law by calling yourself a human resource practitioner, knowing that your name is not in the register of HR professionals and you don't have a practicing license. And I know those are areas maybe we will be discussing maybe during the Q&A. And equally, the IHRM would issue practicing certificates, offering CPDs. And I want to believe this is part of now what we are doing here today to ensure that other than being registered, given that we have got so many laws that are coming up right, left, and center focused on employment, we need to make sure that as a HR, you are not only depending on your qualifications that you may have taken up 5 years ago. And it is a very good thing, given that I also wear the hat of being a practitioner in law, therefore, under the Law Society of Kenya, which it is an equal requirement that you must give evidence that you have been continuously upgrading. You have been continuously upgrading your skills so that you're able to be a current as opposed to a HR practitioner that was just registered that many years ago, but they are oblivious of new laws that have come into place. And I know Chair pointed out the new, maybe the new laws that have come into place, including Data Protection Act, which I will allude to briefly towards the rear end of my presentation. And in this case now, you find a HR that is administering human resource functions in a certain company, and who is oblivious that there is a Data Protection Act that has come in governing what kind of data you collect, how you keep it, and so on. Like I said, I will allude to that. There is so much that is changing, including labor remuneration, which you know would be subject to review over and over, maybe on an annual or biannual basis. So the CPDs are supposed to ensure that you keep upgrading your skills and you are current, so that at any time, capital can count on your advisory. Now, it is also supposed now to ensure, and this is the other part that is very critical, that it is supposed to ensure that once you have been registered as a HR professional, then you must act in consonance with the code that would be prescribed for a human resource practitioner. And there are so many that comes with it. We have had issues. Let me use an example, not even getting a one-on-one maybe on what the code is providing. I could give an example of the legal profession and the code. It would even bring in a code of dressing when you are attending court. And it is very simple. It will even prescribe the colors of the suit that you put on while addressing the judge. It is that simple that we as HRs must also come up with rules about how we conduct ourselves, how we discharge our functions, even how we carry ourselves out there, and whether we advance the professionalization of human resource management or we become a disgrace to the profession. And you will certainly become a disgrace to the profession when you preside over an unfair labor practice in your company. And as you will see, the Act even introduces disciplinary actions against any human resource practitioner that fails to adhere to the code and is not behaving in a disciplined manner in conformity with the profession. And on this one, again, is an area that I know we will interact more in terms of what is expected of a HR. And these are the standards of HR practice. Which are the standards of HR practice? If you advise of a legal, maybe procedure under the Employment Act, let me take a case like a redundancy. And you advise, and the company acts on the advice of a HR practitioner in a redundancy exercise that is botched up. You discharge 100, 200 employees not following strictly Section 40 of the Employment Act, and by extension, fairness under the Constitution. And at that point, later on, the employees go to court, and unfortunately or fortunately, you still have to go to court to be the one justifying whether the redundancy exercise conformed with the requirement of the law. If you fail, that is an indictment to you as a HR practitioner and as a profession. Remember, once the judgment is entered, our names are always there as a witness for the company. And it will keep on being cited in that judgment, which is a public judgment, that the human resource practitioner did this. The human resource practitioner did this. For those who have been in court, you know, you also sit down there to be cross-examined and interrogated, including by your former employee. Those who have been there, I know they are awake to the questions that the employees do ask us. And at that point, they stand at a higher position of power than you. And they will be asking you question. Nikumbushe jina yako? How long have we worked with you? Kwa sababu gani ulinifuta? Hiyo kazi ama hiyo kipimo that you had said that I must finish within that period or that timelines. If it were you, would have been able to finish it within that time. They ask you questions that seemingly may look offensive or may look innocent, but they have a lot of weight. Basically, what they're asking you is, was it fair for you to dismiss me? All right. So looking at those areas, they tell you that those are the standards, and you will look at them codified in that code of conduct in terms of ethics, in terms of your integrity. And integrity, let me share a case that I was dealing with that came out in court. And what happened here is a HR practitioner having executed a separation process. And then later on, an employee sued the company. And what happened here is that indeed the HR practitioner did write letters inviting this person to come for a hearing, and this person did not come for that hearing, either because they did not receive the invite or they just decided not to come. Ultimately, the HR went on and closed the file, and in this case, like typically in many employment setups, employers just go, even in cases that we call desertion, which I'm usually very uncomfortable with desertion. I'm more comfortable with absenteeism. But you just find this person has not come 1 week, 2 weeks, 3 weeks, tried calling, and then all that you just do is just close that file. And closing means just closing, and a marker pen across the file, and you just say closed. And now, later on, in this particular case that I was dealing with, an employee now later on comes up and says I was unfairly dismissed, and they come up with their story, and they say they came up and they showed up at the gates of the company, and they were told by the supervisor to go away. And this happens. But unfortunately, if you cannot prove that it didn't happen, it is actually taken by the court that that was what happened, that an employee was verbally terminated. Now, I was alluding to integrity, because then what this practitioner did, they decided now, after they had been served with the summons, they went out there, did some minutes, backdated the minutes. And after doing that, they took those minutes and the termination letter. Like I'm saying, they had just closed the file, and this was a whole year after they just closed the file without following the process of termination. So there was no termination letter issued. So when they were sued now, they were trying to sanitize backwards by putting records into the company's files and backdating and doing this. And what was playing out in court is that the HR even went to the labor office, because we know we are supposed to notify the labor office whenever there are vacancies or we have terminations. And in this case, they colluded, the HR colluded with a secretary to the labor officer who appended a stamp and backdated. And now these things played out because the employee, through the advocate, said, no, this is not true. This is a clear case of forgery, to the extent that the court actually summoned the labor officer, who had to come and say, no, this was not signed by me, and this must have been collusion. Now tell me how that imputes on the HR practitioner. It is an indictment fail. And this is a clear case where the HR practitioner does not observe integrity, and one that is due for being struck out the law of the register and the suspension of their practicing license. So these are the things, again, I've said, as you read through, you'll be able to pick from the code of conduct, which I've said I will share, to see what is expected of you. Falsification of records, administering or presiding over a process that does not midwife fairness. Remember, again, I'm always taking you back to the Constitution, that every employee has a right to fair labor practice. So we come back, and then why are you terminating this person? Are you terminating them because the supervisor said you must? Are you terminating because the boss has told you, I don't want to see this person when I come back? And in that case, should you be a HR practitioner? And I know most of us obviously would be scared. What if I defy this direction and then I end up being fired myself? And this is where we always come back to the Institute, and I'm sure the chair is taking up note, because part of what the Institute should now be doing also is to protect such a person who has had adverse action taken against them because they did what they were licensed to do. And what they were licensed to is, after hearing a certain matter, they are able to make a decision that, no, I do not find this as a sufficient ground to dismiss someone. Yeah, but most of us do not have either that voice, or we have also not presented ourselves as practitioners who should be the ones guiding capital on human resource administration, as opposed to you being told and your job becomes execution. You just sign a warning letter that was issued by your supervisor without interrogating it. you dismiss because somebody who is not a human resource practitioner has told you itakuwa either this person continues working with you or I leave, and you decide to go on and dismiss that person by fabricating falsifying records and false accusations that later on hit very badly on you as a profession. Because remember, at that point when you will go to court, the manager who told you to do this will not be in court. In fact, even the owners of capital, at that point, the director who told you, can you futa huyu? They will not even remember the name of that person who, according to the act, has up to 3 years to sue the company. So you will not be able to tell them as an excuse that, boss, this is the person that you brought into my office and you told me to fire. They will tell you then, why did I employ you? So either ways, if you execute wrongly, you are in problems. If you decide to be the yes, sir, a HR practitioner, and therefore you're not guided by the law and the code, then again, if ultimately the matter goes to court, you still are in the frying pan because you are the one to justify it before the judge. You are the one to justify it before the union that would have sued on behalf of your employee. You're the one to justify it between the advocate who would have sued the company on behalf of the claimant, that is your former employee. So we need to really balance, and we need also to be vocal so that the institute is also able to give us a kind of a shield. And I'm sure you've seen in other professions, again, let me use the one that I ascribe to the LSK. In the event a lawyer is mistreated anywhere while doing their job, the Law Society takes it up very seriously. And that gives us confidence that I can be able to tell you that, no, I cannot sign a document that is contravening this kind of law, because then it will not touch on my license. And withdrawal of your license is more serious than a dismissal from one employer. And I'm sure if you reflect on what you're saying, withdrawal of your license ensures that you'll never be a HR practitioner again, or at least for the duration that in being removed, you'll have been suspended from practicing. In short, you will be fired from working for anyone as a HR practitioner. Being sacked from unemployment means, as long as you're grounded that you're within your right and you refuse to preside over unfair labor practice, then it gives you a chance for you to be able to work for another employer, and so on and so forth. So those are the areas that I just thought. Generally, as you note, I'm pointing a lot of what is expected. And under the Act, again, I will share this, the best way to also know that you are carrying out human resource functions in line and the expectation of both the Institute, the Act, and the Constitution is always to ensure that you have got the Act with you, you are familiar with the Code of Conduct, you know the consequences that comes to the institution. And to the institution, maybe a good example is when the institution is ordered to pay damages for unfair termination. Those are serious consequences. When an employer is condemned to compensate someone for acts of discrimination that happened under the watch of a human resource practitioner employed by the owners of capital. And to be able to comply, part of it would be, have you done a HR compliance audit? Have you done it internally? Or have you done it externally? Because this is what will interrogate. If I come and look at your disciplinary, let me even not just talk of disciplinary process. Let me look at the generality of your HR manual. Does it conform to the law? Have you had an external party review it for you so that it is also upgraded in light with the emerging issues in law that keeps modifying what may be on that or in that law book that you always use to guide your practice? You will find there are so many acts in that Employment Act that have since been overtaken, having been declared either unconstitutional or unfair. Like, for instance, if you look at the Employment Act as it is now, you will find that it still provides in print that if someone has not worked for more than 1 year, they are not entitled to compensation for unfair termination. But is that the practice now? The answer is no. That has been overruled. And therefore, whether it is a seasonal contract, whether it is a probational contract, then if you are terminating someone, you must terminate that contract in line with Section 41 of the Employment Act. I always get questions like, Wakili, why are you telling us that SICOF should be 30-30? And if you look at the Employment Act, you all know what it is written there. And some of us would even be saying we will allow them 7 days SICOF. Others will say 15-15, others 30-15, others 30-30. And they will be asked, what is the justification? And you see, this is what the owners of capital, the managers, will be asking, that this is what the Employment Act provides. Why are you saying I must give 30 days in full pay and 30 days in half pay? These are emerging areas that every now and then the court keeps changing. If not the court, we find other regulations that provides for more favorable terms than what is provided for in the Employment Act. Many of our policies still provide for forfeiture of leave. Again, you are administering an obsolete thing where you say that if you don't take leave by this time, that you will have forfeited it. The courts have pronounced themselves. Leave has been earned, it cannot be forfeited. Now, we are looking at so many that I could point out that basically means that there is a lot of evolution from the Employment Act 2007 to now where we are 2023. A lot has changed, and that shapes how it is implemented. And who is to implement? It is the human resource practitioner. So that's one of the areas that you have always asked, have you carried out these audits? Do you review these manuals? Or is it that old manual then that is still applicable 10 years later? It cannot stand the test of time. And remember, it will now become the subject of a court process, because it is the document that you'll be using to show that you followed the company's disciplinary procedures as in the HR manual. And therefore, the court's attention now focuses to looking at whether that procedure in your manual provides for a fair process, because the law provides under Section 41 that you must execute a disciplinary action in line with a fair disciplinary procedure. So if that disciplinary procedure in your manual is not fair, then unfortunately, it cannot be used to midwife a fair process. So there is on one side, the fair labor practice from the HR practitioner, but then the instrument they are using to oversee the process. So again, those are some of the areas that you need to look at. And I've said there is that code of conduct that has since been ratified through the AG and gazetted. I've said as at 19th November 2021. I will share that so that it becomes your guide. But maybe just look at the most salient highlights of this code. Is the code, it gives the purpose of the code, and ideally this is to guide the conduct of HR practitioners in Kenya. It provides that it still applies to you, whether actively or not actively, meaning you could have had a practicing certificate or license in the year 2022, which has not been renewed in 2023. This code still binds you as much as you're still carrying out an HR function. It provides who can practice HR. And I'm sure, again, this is something you have all seen coming in terms of depending on the category of membership, whether it's a full membership, what is the academic qualifications you must have, whether it is a primary degree in HR or maybe non-HR, but then coupled with a postgraduate or some other qualifications. At least you know what entitles you to be registered as HR practitioner, and what also entitles you, as a full member, as an associate member, and so on and so forth. And therefore, these will also dictate what kind of functions that one can discharge, what kind of documents can be signed out by a HR practitioner, depending on their level of registration. It highlights duties and responsibilities of a HR. So again, the duties and responsibilities of a HR are as per this code of conduct that is gazetted and therefore laws of Kenya. It is not limited to your JD. Once again, I would want to emphasize that it is not the employer to prescribe the duties and responsibility of a human resource practitioner. The same have been well set out and elaborated under the code of conduct, which is, I've said, is gazetted and parts of the laws of Kenya. And on that basis, for instance, if you are the one presiding, you are the HR practitioner, and perhaps the only HR practitioner in that company, but you find that you have a procedure that delegates HR functions to non-HR practitioners, then ideally, you should know that you're not living to the spirit of this act, because it's supposed to professionalize HR practice. Now, to the extent that you have just been reduced to this clerk who just signs, what we call an undertaker, your job is just to dispose of bodies. A decision was made way back in the field there by the line manager, and your job is just to execute. Now, the question is, do you require a HR manager that is licensed and qualified as such to just sign off a termination, to just sign off warning letters? Is that your job? Can't it be done by a clerk at a lower level? Don't you have a duty to interrogate and make your own rational decision guided by the profession and the labor laws that govern employment, so that you are able to guide that this is not right, we cannot do this? You do that in the interest of the profession, but also in the interest of the employee, and ultimately in the interest of capital, who is likely to suffer very serious consequences for a messed up separation process. So again, those are areas that we need to look at. I have talked about moral and ethical requirements. I will not repeat that. Again, it will be a question of whether what you did is moral and ethical. Look at Section 5 of the Employment Act. It has told you grounds upon which you shall not discriminate at the workplace. Clearly, you shall not discriminate on the basis of ethnicity. But now let us come and carry out composition of your workplace on the basis of the ethnicity. Remember, you are the one presiding over that company to ensure that there is non-discrimination. Would you say that your workplace represents what we call as national diversity, or does it represent your local diversity in terms of ethnic composition, depending on where the company is situated? And I think you have those issues come out very elaborately. At some point, the county governments, for instance, of Kiambu, saying that a big percentage must come from the people in Kiambu. That is against the spirit of the law. And remember, there are other laws here looking at ethnicity, including the National Integration and Cohesion Act, that is basically meant to help us bolster integration of people irrespective of their ethnicity. So if I come to, as Peter Kinyanjui, to audit you, am I going to give you a clean bill that your workplace observes ethnicity or ethnical diversity? What about disabled persons with a disability? The Persons with Disability Act provides that at least 5% of your employees must be persons with disability. Are you compliant? Now, again, you have said we have the data protection, you have the human rights aspect coming in, and so on and so forth, that you could spell out on grounds that you may not discriminate. You've had issues of religion, but you may not discriminate. You may not put a person to choose between their religion and their job. Again, these are things you're hearing on a daily basis. Do you have an environment that allows people to worship and also allows them to work, because they must do both, they have a right to do both? So those are the areas you're saying, look at or that are acting through others that have said on illegal instructions. Illegal instructions. Here you're told this guy should, and then, like I said, being also a HR practitioner, I know I sit on that hot desk, and I know at one point, my director in one of the company I practiced in came with a list of 32 people. And he said that I have received this list from my sources, and I'm aware these are the people who are leading the recruitment of my employees to join the union, and they must be sacked. This is a typical illegal instruction because the Constitution provides employees have freedom of association. Are you the one to sign and dismiss them for participating in union activities? And if such, are you a HR professional? I guess your answer will be self-guided by both the practice, but now what out of this presentation, you're seeing the kind of gravity that is given to you as a practitioner at that workplace. Like I said, I will not be coming in so much in all this, but we have investigative committees, disciplinary committees, that is meant to come and deal with a case of a HR practitioner that violated the code and therefore did not act in consonance with the requirements of the profession. And by not doing it right, then they exposed this person to detriment, and this person has written to the institute or even has raised it in court, and therefore you are being investigated. You as a HR practitioner, you oversee people in a company that one cannot be employed unless they have bribed their way through. You are subject of disciplinary committee. You are a HR practitioner in a company that before somebody is allowed or given a job there, they must give in to sexual demands of the of the supervisors when doing the recruitments, promotions, and so on and so forth. These are the blatant violations that when they are highlighted, they are brought, you will equally as a HR practitioner be entitled to hearing, because that is also part of fair administrative process, but you could have your license withdrawn or suspended for failure to follow the code of conduct as per the code, which is now gazetted and therefore part of subsidiary legislations under the Human Resource Management Practitioners Act 2012. So I've just highlighted generally about the audits that are supposed to identify those gaps in both employment policies, practices that may be deemed to be violating the expected standards in human resource management. And they are supposed to be a self-assessment. And like I know some of us are audited by markets where we sell our produces, but now a HR audit should really not be invoked for licensing purposes only. It can be internal, it can be carried out through the institute, can be carried out through peer organizations that we ascribe to, employers associations and all that, to just ensure that the whole point is to make sure that we have looked at certain checklist documentations, performance management, training programs, termination procedures, grievance handling systems, and so on and so forth. Sexual harassment, those are the statutory policies. You need to check whether you have the sexual harassment, which is a statutory policy. I need to look at disciplinary procedures, which is a statutory policies. We are also now coming in with a data protection policy or data privacy policy, which is also a statutory requirement. We are seeing emerging areas now. We are looking at what we are calling the right to disconnect, which I'm very sure in a few maybe we'll see the light and become law, where again you need to come up with the policies and procedures that guide if one must be contacted outside working hours and how they are going to be remunerated in the event they must be called up. And you see the proposals for violating of those requirements not to contact your persons outside working hours is giving very punitive punishments, upwards of 5 million for violation of such. So these are emerging areas that you must always ensure they are entrenched in your HR policies, manuals, and ensure they guide everybody. Ensure those who help you in implementing these policies also knows the confines of the law and what is required to ensure that you do not become the guinea pig that will be used in court to teach a lesson to other organizations once you are hit with punitive damages for maybe not adhering to a certain requirement of the acts in your workplace. Yeah, we are looking at general environment, you're looking at matters of efficiency, we are looking at performances, we are looking at safety at workplace, which you also know is critical. Basically is overall health, and that helps you to keep aligning and ensure that the HR functions are practices and procedures are in line with not only the Employment Act, not only the requirement of what you call the labor laws, but also conforms, because I know most of us, the jobs or the businesses that we preside over are extraterritorial, meaning they traverse the boundaries of Kenya, and therefore they must also ascribe to best practices internationally as per the International Labour Organization conventions, which, as you are aware, is part of the laws of Kenya by dint of the Constitution of Kenya 2010. Okay, so I will not be saying so much on that because I know there will be questions on that. And yeah, I have highlighted that. I said I will share this so that we don't delve so much and create time. I can see some questions on the chat there. I've said international standards are part of what you should always watch. A good aspect here in what is emerging as internationally is that we are seeing an approach where labor laws have been now entrenched very deeply into as human rights. So they are now not only labor rights, they are also human rights. And I would want to allude to what happened in the example I gave earlier in one of the companies that lined up their female employees, asked them to strip naked just to see who had disposed some used sanitary pad. Now, here, of course, is a Wazira's management staff. I don't even want to blame the company because this, I'm very sure, is not a company policy. This is a policy of just a few of Wazira's managers there. But then now let us look at what happens to these ladies who are taken through that. These now, if you forget that they're your employees and pause to the point that you employed them, and you recall that part of the documents that you did ask of them as a condition of employment is that they needed to prove that they are Kenyan adults through their IDs. That should wake you up that the persons you have employed there are adult Kenyans. And adult Kenyans are protected by the Constitution of Kenya before they become subject of your policies, before they become subject of your practices. So in this case, this is where you find that the attention to this kind of practice in that company is now not limited to the perimeters of the company. It is taken by the media, it is on national news. Okay, it is taken by human rights, it's taken by unions, it's because it is an affront. It is taken by human rights lobbies because this is what is protected by the Constitution. The Constitution provides in Article 27 very clearly that every Kenyan has a right against indignified. You must treat them with dignity, has a right to be treated with dignity. So here, having your practice to ensure that there is proper disposal of sanitary pads, that the way you enforce it is by having ladies strip naked. That cannot be entertained, not even if it is entrenched in your policies. It is against the Constitution, and these persons will not sue you, not for compensation for unfair termination, but they will sue you because you have violated their human rights under the Constitution of Kenya. So once again, like I said, every act that comes into place, every act that prescribes such codes, every act that provides for registration that is mandatory, must also provide for penal consequence for any persons that does not conform. And looking at the Human Resource Practitioners Act here, it is very clear that any person who practices as such, not being registered, not being eligible and registered, such a person will be committing an offense and be liable on conviction to a fine not exceeding 200K or to imprisonment for a term not exceeding 2 years. So again, as you can see, the act means business, because you call yourself a HR practitioner, or you have a contract where you're employed as a HR practitioner, or you introduces yourself as a HR practitioner, knowing that you're not qualified to use that title under the act, you're looking at 2 years in jail or 100,000. And I say it is not isolated. It is the same with that person who opens a clinic out there. An example of what we all went through of one Mr. Mugo in Nairobi. You know what he was doing, not being registered as a medical practitioner, and you see the consequences for such. That who masquerades as a lawyer, that who masquerades, call them whatever, it is the same here. If you're not qualified and registered as a HR, please do not use that title, because it immediately now provokes criminal sanction, which, as you see, is quite punitive. Falsifications, giving forged documents or registers, again, is an offense, and the same, again, attracts the same consequence. So you always have a declaration that you sign that whatever information you have given there is true. If, however, they are false, fraudulent, forged, whether orally or in writing, it is an offense, and you will be, upon conviction, looking at 200,000 or 2 years, or to both. And when we say to both, is maybe if this is a repeat offense, or that one that in the discretion of the judge requires that high level of punishment. Like I said, these audits can be done with peer organizations. I will be giving that, but maybe just to use the court, the lens of the court, to just show some of these cases that have gone in the Employment and Labor Relations Court, and what the court felt that is the space of Human Resource Management Professional Act in the realm of labor administration. And here, the generality of this case, which you can always download it, I know I have them downloaded broadly. I do not want even to direct ourselves into what were the issues in these matters. But in this particular one here, the human resource practitioner of this company sought to represent the company. It was initially being represented by lawyers, but the company decided to act in person, and therefore the documents in court were drawn by the human resource practitioner. And the question that were appearing before the court is that the court analyzed, first of all, whether that human resource practitioner had that right to file those documents on behalf of the company. And here the court was diverting attention from, it is not what you say, it is not how you introduce yourself in court that I'm the human resource practitioner. It is about, are you registered under the act? Because registration as a human resource practitioner is not domiciled within the confines of one company. If you are a human resource professional, you can act as a human resource professional anywhere in Kenya, in any company. And therefore it's not domiciled. So it's not the company that accords you the title human resource professional. It is the act, and this is what the judge is saying here, that you have to look at whether you are registered and you have a valid practicing certificate. And on that basis, in this case, the case was entirely lost because the HR could not justify before the court that they are not quacks. They could not justify that they are licensed to practice the profession. In fact, just picking from the case is that human resource management has evolved into a profession, which, like the legal profession, must be regulated and shielded from the intrusion of quacks. That is the court that is saying this. And therefore, again, in advice to many of our colleagues, please do not go and introduce yourself in court as a human resource practitioner. If you do not have that card that you're able to show the judge that, look, this is my membership for the year 2023. Because one to you, if you are asked to produce and you don't have one, because you are likely to be convicted right then, because you will be representing yourself as a human resource practitioner against the law. And actually you are that bold enough to go and confess it before the judge that I'm here before you, calling myself a human resource practitioner, knowing very well that I am not one. You will be jailed, or the fines that you've seen. And this is meant to protect the profession. As I said, it is this kind of double-edged sword that is protecting the profession, but while it imputes a very high level of responsibility to such person who is such registered to practice as a HR. So again, those are the things that I've said, which I know you will look at. Another case that you may also need to look at, again, touches on the matters that was brought up. The 8 others here were persons who were using the title HR manager. And you see the title HR management professional varies, is wide. You said some call them HR officers, others HR managers, others HR business partners, others would be HR directors. The focus is in this HR. Are you licensed, qualified to practice the same? So in this case, the union took up these cases against these practitioners or the persons, and they challenged that whatever actions they were doing in the organizations they were representing were null and void, given that they were not registered and licensed to practice as provided for under the HRMPA Act 2012. And of course, there were now serious discussion where the act and what it requires played out in court. And what I would say again, like I said, I'll be sharing a lot of this, is now it is a statute that provides for establishing of IHRM to regulate examination, registration, and regulation of standards and practice of HR management. Okay, so that is an act that is binding to the judge, and provides that under the same act provides that there will be registration. Okay. And Section 19 provides for qualifications and criteria of eligibility. It is in the Act. it provides that it can institute disciplinary action against any HR practitioner that may be guilty of professional misconduct. It is there in the Act. And most importantly, the court is of the view that since ERRC, the Employment and Labor Relations Court, being the special court division dealing with employment matters, to the extent that it is Employment and Labor Relations Court, then the IHRM Act is one of the primary acts that guides it. And by extension, when it is making any determinations, it will be the assumption that the HR management practice is being handled in line with the law. And this is where now the court says that it has direct jurisdiction, given the heavy role and mandate of human resource management practitioners hold. Their conduct, management, registration, and practice would be of great interest to this court, which deals with the employer-employee relationship. And in the wordings of the judge is that to state otherwise would be to miss the point. So ideally here you're saying that your conduct, your registration status, your licensing status, and basically how you executed a HR function is of direct interest to the court. And wherever you go there, any document that you have signed, you should know. It is basically supposed to point out on whether you are discharging your mandate in line with the Act of Parliament. So having said that, and knowing that there is, we will read all this, but having said that, perhaps before I just point out very briefly on the data, perhaps I could go back to the moderators, see whether there are areas that I need to clarify on that. But the generality of the Human Resource Practitioners, Human Resource Management Practitioners Act is to ensure that on one side, you protect human resource management as a profession, create punitive consequences, regulate the practice by registering and setting standards, while on the other, ensuring that those who are now registered and compliant discharge their functions within the expectations of the law and the code of that profession. So perhaps I could get a question or two.
Amazing. Such an insightful session. As the participants also agree with me, we just have a lot of positive responses from the chat section. Maybe just one question, because I can see that the question that Erastus asked was already addressed. The question on how come the roles of a HR practitioner are not outlined in the legislation, but you were able to address that you can get that from the HR Code of Conduct. But we have a question from Jane Wanjohi Wakili. Jane asks, if a HR left their previous employer and now there's a lawsuit, does the former company that they were working for or court have a right to call upon that HR, or will the burden fall to the current HR in the organization?
Can I take that, or do you have another one?
You can take that one.
Okay. Yeah, it's a very good question. And here I want to believe is a situation where you inherit obviously a mismanaged case and you're the current HR practitioner. And what will matter then, just like in any other profession, it is not about who is your current lawyer. It's about who drafted that agreement of purchase that has brought in that problem. It is that HR who would be in problem. It is not one who was employed last year, maybe that is 5 years after the issue or years after the issue that went in court. Obviously, once this child has gone out and you don't know how they separated, you may not be able to compel them, and sometimes you don't even trust them to come and testify in the interest of the company. So you might find yourself being the unfortunate HR who has to go and defend the company on a matter that you know was not well managed. And this is
Sorry, I think we've lost Wasili, but as he joins us, we shall kindly please keep your questions coming. Keep your questions coming. We will be addressing them in a few minutes. Wasili, karibu tena.
Yes, sorry, I think there was a net hitch. So I'm saying, unfortunately, you might find yourself being the one to go and defend the capital where the HR has since left, in which case you need to have, first of all, to give advice. This is where, as legal practitioners and also as an emerging way in court, we are always advised to advise capital on alternative dispute resolution. We could have it arbitrated out of court, and especially if you know that you have no chances of winning, please advise properly and let us look at whether there are other amicable settlement short of waiting for a pronouncement by the court. Thank you.
Okay, great. I think Jane, your question has been answered very nicely by Wasili. I will just have comments like Pamela is saying awesome conversation. Someone is also commenting. He says that we would be having such more conversations that are educative. Matthew says it's a great presentation. We have Elia saying it's a great presentation. Pamela, I think, was commenting on a previous concern that the owners of the company have managed to engage an advocate. Therefore, you as a professional, you stand on your own. Human resource practitioners stick to your professional code of conduct and stop being rubber stamped. Great comment, Pamela. We have a question from Jim. Can a HR push the employer to cover them with a professional indemnity cover, especially where employer doesn't listen to his HR? Jen is asking, Wasili, allow me to go one more time. Jen is asking, can a HR push the employer to cover them with a professional indemnity cover, especially when employer doesn't listen to his HR? Over to you, Wasili.
Yeah, about the professional indemnity. Yeah, it is always a requirement for all professions, and especially when you are acting as a representative or an agent of the company. You realize, and I have seen this happen when you could find a former employee decide to sue the company and also sues the HR practitioner. And it is very possible because you might be executing what ends up hurting somebody and contravening their human rights, but then you're not doing that as a person, you're doing that on behalf of the company, and that is a typical case where professional indemnity covers should be in place to protect HRs against such personal suits. And these are also the things that I'm sure through the human resource management are supposed to come up with such welfare things that are supposed to help a HR practitioner who is in distress for discharging HR functions. And I'm very sure there are quite some number of schemes either ongoing or in the making for the welfare, because that's one of the mandate of the IHRM, to take care of the welfare of the human resource practitioners and ensure that they are not intimidated while doing the job that they were licensed to do. Thank you.
Okay, great. So thank you, Wasili, for that. We have another question. One asking of the consequences of HR practitioners implementing illegal decisions like stopping of salaries and the like. Karibu.
Again, yeah, I like the way the question is coined because this is implementing illegal. Now, you have your code. You are supposed to implement the law. You are the custodian of the labor laws in your organization. And therefore, if somebody gives you instructions that clearly are against, then even if you look at Section 44 of the Employment Act, and where we talk of or allude to failure or refusal to obey lawful, it always underlines that, leave alone you as a HR practitioner, even your employee can refuse to obey unlawful instruction. They are only supposed to obey lawful instructions. So if somebody tells you, no, I cannot do that because it is against the law, like for instance, let me take a very basic example of a matter that I was dealing with here about the company realizing that in doing the recruitment, somehow they failed to notice that a lady engaged was pregnant. And therefore, just 3 months into their contract, they're into maternity leave. And these attracts the wrath of the company. And I know these are things that happens behind there, but very emotive. Now, you as a HR know that the Employment Act provides for safeguard, that this is one of the grounds that an employee should never be discriminated on. That is maternity or anything attributed to maternity. Yeah, this is both under, under discrimination on the basis of gender and maternity status. So now, you are instructed that you can now not renew or confirm this employee because they have realized she's pregnant. Is that instruction you implement? That is an illegal instruction. You have a duty to advise, and in this advising, I do not mean that you defy the management. It is you advise that the consequences for discharging such employee, and if they were to go to court, they are going to be far much outweighed than just waiting for them to finish a contract of 6 months or even 1 year and pay them maternity, which is limited to 3 months. This is an employee who maybe if you put them on maternity, just have, maybe they're on a salary of 20,000, so 3 months is around 60,000. But if they sue that they were discriminated based on their maternity status, we are looking at them getting compensated to an upward of 60 months of their gross. That is discrimination. For unfair termination is a maximum of 12 months. Discrimination could go upwards to 5 good years of paying someone salary. So these are the areas that you also, I do not want, and I know having also practiced as HRs in this company that we know the overheads, the capital overheads are very material and critical. It is you to actually show that taking that action of just dismissing these is a very small cost as compared to what would happen if this person was to go and sue the company. So illegal instructions, please advise and let your signature not be on that document that signs an illegality being a HR practitioner, because you're also looking at losing your practicing license. Thank you.
Wakili, I think somebody, Erastus Deleva, he has raised his hand. Allow me to just allow him to speak. Erastus, you can speak. Erastus, you can unmute and then proceed.
Sorry. So what I'm asking is, we have like the PFM Act. It's very clear what an accountant should be able to do. We have the Procurement Act, the PAD. It's very clear that a professional opinion must come out from the one in charge of procurement. Now we have HR where boards are not, there is no HR professional in some of these boards, especially in the government. And the chief officer, or rather the accounting officer, together with the board, they make a resolution either to fire or whatever to do. And you will not even find the footprint of a HR. So I'm asking now, is indeed time that the HR Act is reviewed in a manner that the signature of HR can be seen? That's my submission. Thank you.
Thank you. And Rastas, Wakili, you can respond.
Yeah, and very well put and observed, Erastus. It is true, and you've seen the Institute and other stakeholders actually take up active suits against appointments into even government boards, the public service and all that, where you feel that the person who is being engaged to do that should have HR functions, HR qualifications. And these, I'm seeing it coming up where you find now in advertisement search boards that are supposed to carry out human resource functions. It is becoming now more of a norm that you must have people who are adequately skilled and licensed, so that as they make up decisions that are human resource oriented, or that are keen to carrying out human HR functions, the board should be properly advised. And this is now what most of the companies are looking at. You will find the HR business partner and director being entrenched up there, as opposed to what used to be there, where it was just meant to be down here and just implement. Because as a HR practitioner, you have a duty. First of all, it will be exposing this board to carry out, if it is indeed carrying out HR functions without being guided by a proper HR licensed practitioner. That decision is likely to be defeated in court if it is taken by what the court is calling quacks. Because indeed, if you're not trained, registered, and licensed, then you are a quack. Irrespective of whether it is a board, you'll look at what is the composition, did it have power to make that resolution. But then again, from us, we look at our systems where we are saying that the HR practitioner who is registered nationally should not be used to implement decisions made by non-professionals. If you come to me as a lawyer, we listen to what you tell us. But you see, ultimately, I will tell you, unfortunately, you want me to do an agreement? Yes. You want me to put my stamp there as Mwangi Kinyanjui advocate that I'm the one who has seen you and you have sold to each other? Yes, then you have to do it my way. Otherwise, even for us in our practice, sometimes we get these agreements drawn by some brokers out there and they come and tell you, Wakili, tunataka tu stamp yako. If I am a professional advocate, I cannot put my stamp there, because by putting my stamp, you are telling the whole world, in case there is a dispute surrounding that agreement, that you're the one who drafted it and it conforms to the law. So for you also as a HR, even for instructions given by non-HR practitioners, ask yourself, do you want your signature to be the one that is on that document? If the board is the one making decisions to fire, then why can't that letter be signed by the chair of the board? So those are the areas we are saying that we need to keep interrogating to align, fight for the space of HR professionals, and where the institute backs us up, so that eventually now we will not have those situations where a HR practitioner is actually required by dint of the employment contract to implement decisions made by an HR a body that does not have HR competencies. So that would be my take, just responding to that observation from Erastus.
Great insights, Wakili. Erastus, I can see your hand is still up. I don't know if you are still will unmute you for you to clarify whether you still have something to ask as we proceed to the other questions.
No, Florence, sorry for that. I'm okay and well answered.
Okay, sawa. Martin hand is up, so Wakili, allow us to take Martin's question as we go through the ones in the chat section.
Thank you.
Martin, unmute.
Yes, Martin.
Can you hear me?
Yes, we can hear you. Please proceed.
Thank you very much for this very insightful session. Mine is just a concern, for lack of a better word, but sometimes we, HR, normally we are custodians of labor laws. But sometimes we find ourselves in a very difficult situation that the management, like for example, the management is insisting that kindly we need to fire this employee XYZ. But as a HR, you go ahead and advise the management that due to reason A, B, C, D as per the labor laws, then this doesn't qualify to fire this person. But I have a friend of mine whereby now the management decided that they considered this HR to be like very coward in terms that he did not act on the good faith on the side of the management. Now my question is, does the IHRM have this provision that safeguards its members, especially when it reaches to a time? Because most of the time we as a HR, we don't have like we find ourselves that we are isolated in terms that maybe ourselves were being fired, maybe not in terms of following the due process. Thank you very much.
Yeah, thank you for that. I'll be throwing that later on as we do the closing, or as he does the closing remarks. That is back to the chair in terms of the safeguards that are put in place by the institute to protect, because yes, they are part of the mandate of IHRM is to take care of the welfare of the human resource practitioners. And that certainly would mean, like, for instance, I would say, if for the legal practitioner, like I had said, if I'm sued or I face political reaction because of doing what I'm supposed to do, sometimes you have to defend people against the wishes of the state and something like that. You always find the comfort in having LSK stand with us and say that this is what this person was registered and so on to do, and everybody has a right to be represented. So it is the same that you're saying. There need to be elaborate support that will give HRs the muscles to literally, to basically be able to advise the boss and tell them this is against the law and this could cost me my practicing license. And as such, I will not have my signature on this document. And I've seen that happen to many employment setups where you tell them it will not be my signature on that document. This is one of the stalemate that you are saying that it needs to be protected. And the person to protect this HR practitioner is the same custodian, that is a statutory organization that has called on us to observe that code and advise legally and professionally. So it should protect us in the event that out of my refusal to obey illegal instructions, I have had myself fired. So these are some of the areas that I thought IHRM should even have their own legal department, that they're able to take up this matter on behalf of this person. And this is the only way that the HR as a profession will equally be protected, and so on and so forth.
Great, thank you, Wakili. Thank you also, Martin, for that question. So we have a question from James. James is asking Wakili, what happens when you give an advisory to the CEO and he or she doesn't take the advice, but rather proceeds with unfair termination?
Yeah, that is one of the typical cases. You're saying, yeah, you give advice. It must not be taken. Let's agree on that, because it is not our call. It may not be taken. What I've always advised my colleagues is we make sure that our advisory is done in writing, clearly illustrating or telling the employer about the consequences, citing the relevant laws. But then in some cases, the employer will end up taking that decision, having assumed the risks. Now, if they decide to do that, I wouldn't be worried as a practitioner. If, however, it is the other way around, I would be very worried, because if I go and just proceed and execute and then it comes around to hit the company, you will find the same manager, the same director who instructed you to do that will now all of a sudden disown you and actually put the burden back to you that you had a duty to advise them properly. So put it in writing, and like you said, have the IHRM also come up with elaborate protective measures against such a human resource practitioner that is intimidated.
Okay, Wakili, I think the questions that are being asked are similar to what you just addressed on why IHR should be sued when they are acting on the orders of the company. I think all that is, maybe just to confirm with you, Wakili, you were to take us through data protection section just briefly. Is that still on? Are you going to just share, even if it's a few minutes of insights on data protection?
Maybe just to introduce, in the interest of time, I can say it's just about the hour. And I was also guided by the good chair that we will be convening maybe, I don't know, within what timelines, so that I give justice to the team in terms of the Data Protection Act. As it was said in the introduction, I am a certified data protection officer, and therefore well versed with the Data Protection Act. You have seen what has been going on in terms of public announcement through the Office of the Data Protection Commission. In terms of heavy penalties for maybe clubs that have used patrons' photos, educational institutions where you have used photos of children, graduates out there to advertise the business, whether on your websites, on your brochures. We have seen cases where employers have been sued for violation of personal data, including medical data for their employees, which goes to third parties that are intended. Sometimes when administering CCOVs, you find that we come across a lot of information that touches on medical ground. This Data Protection Act has been enacted in line with Article 27 of the Constitution to ensure privacy. And it is just the same to what I had earlier alluded to, that the right of privacy, the right against arbitrary research, the right against disclosure of information, including information about people's families. If you look at the Constitution, it says every Kenyan has a right not to have information about their families unnecessarily disclosed. And in our presentation, the next discussion would be to look at then how, for instance, if you ask someone a question of, are you married? You need to know when is the line. If somebody is telling you, I was unwell, I was sick, and you are telling them, what was the problem? Can I see the documents? What documents are you asking of? If someone is telling you, I am pregnant, and they are disclosing, what is the duty for you to keep that information confidential? Because if it leaks out, then you will be strictly, as an organization, be liable for that. This is an emerging serious compliance issues in most of the companies. The Act requires you to be registered if you're handling sensitive data about people. And here, sensitive data, the way it is being defined, or personal data, the way it's being defined, is any data that can be used to identify a human person. This could be your ID, this could be your photo, this could be your email address, this could be your vehicle registration number, this could be your image. It is so wide so that let's not just be focused on the photo that was taken in a club. I want you to focus on the information that you obtain from people, including their mobile phone numbers, how they are collected, what explanation is given to the persons, whether you have CCTVs, whether you have biometrics all those are personal data. And now this act brings in regulations to control how you obtain, how you keep, how you share, how you destroy such data. And this is in line with international principles. And the punishment for breach of such data is so punitive. In some extreme cases, it is a percentage of your turnover as an investment. So it is an area that I know we are quite busy at the moment backing organizations in terms of, first of all, registration. I would ask of those represented, how many are registered with the Office of the Data Protection Commission? Because if you're not registered, you're already in violation. If tomorrow you're audited or there is a complaint, you'll be in very big problems. You need a policy on data privacy in your company. Most importantly, you need also to have people handling data properly trained so that they're able to implement this policy. So I would just just like I've been guided by the chair, I would had suggested if we can put it back to back, but we thought the session would be very short. So with our own self-organizations, perhaps we can get a time when I can take you through the provisions of that data protection and also how we can lead you towards compliance. But in the meantime, we have also shared our details, the contacts, and also the email contact, so that in the event, even prior to such meeting, you'd want to meet us and we help you towards compliance, we can work together and ensure that you're compliant on this front. Another emerging areas is on issues of human rights that I had alluded to, that you also have to make sure your policy also pays tribute to human rights, which are now, as I've said, labor rights are now being entrenched as human rights, and therefore the repercussions for violations are actually quite severe, and we need to look at how we implement our policies in a way that is humane. So having said that, and in the interest of time, again, I remain available both through the Institute and personally for those who want to maybe follow up on a query that we may not have fully ventilated on here, either through calls or through email. But in this regard, let me thank you so much for allowing me to have this discourse with you. But perhaps back to the team moderating, just in case there is a question that I should answer just before we knock off. Thank you.
Okay, amazing, Wasili. Thank you so much for that. You have concluded it quite well. As I said before, the questions that have been filling in are questions that you were able to address earlier. We just have questions on members asking about the code of conduct and also the slides. I think you had mentioned that you would share, and I think that seems to be with liaison with the co-chief and branch chairperson. So I think we are covered on that, members. Worry not. Yeah, so I think we are done for today. So members, we shall call it a close. Wasili, Peter Kinyanjui, we really wish to appreciate you for taking the time to take us through this quite comprehensive topic, but we have narrowed it down in a way that we were able to really understand and we were able to resonate with. All of us, one of the members in the chat mentioned that they are an upcoming HR professional, but were able to really grasp so much from the topic. Asante sana for breaking that down. And also, most importantly, for giving us a clear set on data protection, which we really look forward to learning much more on as a trend in HR during the next session, of course, with guidance from the Coast Eastern Branch leadership. Asante sana tena. We cannot appreciate you enough. So members, join me in appreciating our Wasili Peter Kinyanjui in the chat section with a round of applause. Thank you. Just sending him messages of appreciation, you know, those emojis, reactions, just throw them into the chat section. Use all the reactions that you can find just to appreciate him for the great job he's done. I mean, all of you can really join me in really saying that he's done an amazing job. So Wasili, we can appreciate you in so many ways. But from us, is just to say thank you so much. for taking your time. And on a Friday, I mean, the weekend has just begun, but thank you so much for taking your time to really share this with us. And I believe, even as the members have mentioned, they look forward to having you over and over again. So wakili ukitoka kukuwa na sisi as the Coast Eastern Branch professionals, we look forward to learning so much more from you. Members, thank you so much for being here. Thank you so much for taking the time to be here with us. And without further ado, I will take it to our chair to give his closing remarks. And then after there, we will have one of us close with a word of prayer. As we call this a close. Asanteni sana, be blessed. I've been the moderator, Florence Mkangondi Fundi, a HR professional from Taita Taveta County. Thank you so much and blessings. Chair, over to you.
Thank you very much, Florence. Thank you, Wakili. You have done justice to the compliance, particularly the HRP Act. And I think you have really elaborated well. And I was looking at the charts, and then so somebody, this anonymous, say there are members who are still pursuing the CHRP, but are full members of IHRM with HR background. Are they in trouble? Then somebody is asking, yeah, are they in trouble so that they stop doing their work? They are not in trouble. If you're a member of IHRM, remember we have been under transition, leave alone before we are doing the CHRP and all what has been. There's so many people who have been doing HR, maybe the higher diploma, the diplomas, and all those. All of them are members. Those who have registered as a member of IHRM. So we are not closing you out. You are not in trouble. And then there was a question raised by Martin about the welfare. I know a few cases that where members have written to the IHRM, particularly to the ED, and ED have stood with them. Only that now I will also, it is good, something that we need to find a way on how the communication can be done. But otherwise, yes, IHRM stand with the members, especially those who are victimized from one point. But of course, we understand that it has to come to be something that you actually playing your role as HR professional, not the examples that Wakili was giving us. But now you're doing this, trying to sanitize the process. So basically, those are the things that it happened, but only that we need to find out how do somebody make the communication, and probably the line of the channel of communication in regards to a complaint from a member who is being victimized. Otherwise, Florence, you've done good thing. Thank you so much. And I think, as I said earlier, I think data protection is another thing that we have to discuss. And probably, Wakili, you will allow us to probably plan with the team, and then we come out very clear on it, so that we give you a very humble time that you can take for everyone here. And I really appreciate that we also have people all the way from Migori. I saw somebody from Migori. That is nice. That is good, because the message is going across. So basically, that is nice. Is good to have everyone here. Having said that, Florence, I don't think I have any other thing. Maybe Erastus, we have an assignment with you, and I want to believe we will actualize that assignment. You want to say something?
No, not really.
Okay. So we have assignment with you. We want to actualize that assignment. I would also wish to have, but I'm not seeing him here, somebody from Cliffy. We have also another assignment that we need to actualize from the other end. So having said that, back to you, Florence, and thank you very much, all.
Thank you so much, Chair. Asante sana for your closing remarks, very insightful. You've also summarized the session quite well. So without further ado, Erastus, you have been an aggressive speaker today. Allow us to welcome you to lead us in a short prayer as we close the session. Erastus, Kazi.
What am I to do?
Kindly lead us in a short prayer as we close the session.
All right, we can pray. Father, in Jesus' name, we want to thank you for this time. Thank you, Master, because of the wonderful presentation. Commit each and every person before you're gone, and we pray as we are committed, meet again. Lord, you shall be with us, O King of Glory. Thank you and we love you. In Jesus' name we pray. Amen.
Amen. Thank you.
Amen.
Thank you very much.
Asante sana, Ras, for leading us in that. Members, thank you so much for staying put up to this point. Asante sana, Wakili Peter Kinyanjui. Thank you, Chair Coach Eastern Region Branch. Thank you, leadership, all the branch and IHRM leaders present who we were not able to recognize earlier. Asante sana, IHRM members, members who've joined as friends of the Institute. Asante sana for being with us up to this point. Wishing you all a blessed weekend. Feel free to live at your own life. Thanks.
Asante sana wakili, wafanya justice kwa hii masomo.
Asante sana. Thank you.
I really
Thank you all. Thank you all for the compliments. Goodbye and have a good weekend.
have a good
You
weekend.
too, you too. Goodbye.
Bye.
Thank you. Florence, kazi mzuri hiyo. Kazi mzuri kabisa hiyo. Thank you so much.
Asante sana, Chair. Thank you also for this session.
Yeah.
So we can leave, right?
I saw Vera somewhere. She has disappeared. Vera.
She disappeared.
she-
She was engaged. She was engaged
Yeah.
to dog, so she was not able to join.
Okay.
So Chair, allow me to end the meeting.
Okay. Thank you. Thank you so much.
Okay, thank you. Blessings, Chair.
Okay. Dorothy wasemaje?
Mimi ndo nimebakia kwa wall peke yangu.
No, we still have 20 who are.
Sasa nakuuliza
Usiulize.
Wacha nikuulize bwana. Can you share these notes?
Yeah, it will be shared. Let's because it is recorded. By the way, if you go to YouTube, you have the whole thing.
For YouTube, eh?
Yes, if you go to YouTube, you have all the document because we protect the the slides.
It's okay.
So
Okay.
YouTube actually has everything. You can, if you check,
I can go to YouTube.
Yeah.
So it's okay then. Thank you.
Thank you. Asante sana bwana Nyongesa. Thank you so much for attending. Asante Koech and Nduta. Thank you so much. Charles Mwangi, CS Patrick, Ngeny. Thank you so much. Emma, thank you so much. Elizabeth, Hannah, Helen, thank you so much. Thank you everyone for coming, for joining us today. God bless you. Have a nice weekend.